Yes, okay. My name is Jocelyn Larkin, and with me today on my panel is Alexandra Lahav, Professor of Law at the University of Connecticut, and Ahilan Arulanatham, who is the Senior Counsel at the ACLU of Southern California. So our topic today is litigation and democracy. The Impact Fund's mission, as all of you know, is to assist all of you to use litigation as one of the tools for social change. What we have found in the past couple of years is that there has been a very significant renewed interest among the progressive community in what we can do with litigation. And in part, that's because there's a perception that the both executive and legislative branches are closed to protecting the communities that we care about or in making any kind of progressive change. What we've also seen is a lack of federal agency enforcement of the regulatory regime that protects our clients in many circumstances. I think we've also all been very conscious of the impulsive and sloppy shoddy policy making of the past couple of years that has, I guess, compelled us to go to court under many circumstances. And we have all worked very hard the past couple of days getting down into the real nitty-gritty of how we do the work we do, what are the best practices, who do we call, what are the cases that we need. And what we thought we would do to close the conference is to take one step back and really think about what is the role of litigation in a well-functioning democracy and also in a poorly functioning democracy. Because I think all of us know why we do our work. We do it because we care, but Alexandra particularly has spent time thinking about how our cases matter as part of our democracy. So let me begin by turning it over to Alexandra to talk to us a little bit about what the role of litigation is in a democracy.
So thanks so much, and thanks for staying so late and being patient, and for inviting me. It's really an honor to be here and to have. Is it not?
There it is. There we go.
And to have the opportunity to talk to you all. I'm really happy to be here. So I want to start by just saying a word about the philosopher Hannah Arendt. And you may not think that the philosopher Hannah Arendt has anything to do with what you do. But she developed this idea in her book on totalitarianism about the right to have rights. She wrote about it in the context of displaced persons in Europe after the Second World War who had no country. And so in the countries where they were, she observed that the only way that this group of people was able to get the attention of the state was to commit a crime. And if they committed a crime, then the state would notice them and impose penalties on them. But otherwise, they were almost a non-person, a person who has no recognition from the state. And so she, in response to thinking about that, she developed this idea that the most fundamental right is the right to have rights at all. And then we can have a conversation, well, what rights do I have once I am a person who's entitled to have rights? And so the book is really structured, and my idea about why I think what you do is so important, is really structured around this idea that people have a right to have rights. And the way that individuals or groups that aren't recognized by the state can bring to the attention of the state that they've been mistreated is through the court system. That's what we, at least in the United States, that is the way that we access justice. And so in the book, I talk about 4 things that litigation does for American democracy. I should start by saying that I'm not saying that litigation is the only way to achieve positive social goals. I think it is one traditional way that we have in the United States of doing that. And that's why we have so many lawyers who are engaged in that project. And so these four things are, one, promoting social equality between individuals or groups. Two, participating in our own governance. Transparency, that is revealing information that people want to know in order to make decisions. And then enforcement of the law. Now, usually when people think about litigation, they pretty much go to enforcement of the law. And Ahilan and I were speaking earlier about how a lot of people, I think, rightly understand their job, that is lawyers, as measured by the outcomes that they're able to achieve at the end of the day for their clients. And I'm not saying that's not an important measure, but I guess I'm trying to say there are positive externalities to the other things you do, even if the outcome isn't everything that you would have liked when you set out to bring the lawsuit. So I'm going to say a couple words about each of these. So what do I mean by social equality? This is an idea that I got from another philosopher named Elizabeth Anderson, who's written a couple of excellent books, one about workplace equality that just came out recently, and another one called The Imperative of Integration. And she talks about this idea of social equality, which is different than the idea of all of us being exactly equal in terms of resources or something like that. But rather the idea that we're all entitled to what Ronald Dworkin called equal concern and respect. And one of the things that litigation does is it allows people who are otherwise downtrodden to come before a neutral and say, look, I was wronged by this other person, even if that other person is incredibly powerful. So the case that I found kind of the most meaningful in this regard, and I think you guys can tell a million stories about this, is Casales against Kelly, which is a case out of New York City, in which a group of homeless people sued the city of New York for engaging in various types of First Amendment violations and misconduct with respect to that population. And the thing about that population is that the voters didn't really care about them. And the city council at the time, this was under Mayor Giuliani, if you remember that he was once the mayor of New York, they didn't care about them. Nobody cared about them. And many people just wanted them off the streets. And so that's what was happening. And so the question is, well, who is there to look out for that group of people when they're being mistreated? And I would say at the time in New York City, that was among the most despised and mistreated group of people. And who was there? Well, a federal judge was there to say, this is wrong, what you're doing, and you need to change. Now, was it a long fight? Even after the judge had pointed out, this is wrong, you need to change? Yeah, it was 11 years. It ended with sanctions against the city for contempt. But that said, I don't know where else in our society we're going to obtain that level of social equality where a homeless person can stand against the city and say, this is how I was wrong, right? Through the medium of their lawyer, but still. So that's social equality. Then there's the issue of participation. And increasingly, I'm really concerned in our democracy with the increasing assault on people's right to vote. That one of the major ways in which we participate in our own government is by calling attention to problems through the medium of litigation. I'm not sure that's the greatest for every single problem that we face, but it is an increasing trend that we're seeing because so many voices are excluded from the political system. And there's lots of ways in which we participate in our own governance through litigation, by pointing out when statutes are unconstitutional or when misconduct has occurred against the government. And also with respect to employers, we had a lot of conversations today about employment litigation. One of the major entities that controls our lives are our employers. And that's a really important part of self-government, I think, is not only understanding the government in the sense of the United States government, but also the other modes of governance that control our lives and the way in which we can take stands against them through this medium of, again, having a neutral arbiter who can help us. And we'll talk about neutrality in a little while. And then the final point I want to make is about transparency. So I don't know if you guys saw, but ProPublica recently published, I think it was yesterday or the day before, a deposition with one of the directors of one of the Sackler family, the director of Purdue Pharma. If you haven't seen the article on ProPublica, I really can't recommend it enough. But that was a deposition that the reporters got because it was leaked. It was not made public. And it reveals a lot of disturbing information. And in a lot of situations, we're only able to know about things that occur because there is a litigation where people in power are forced to come to account and to answer and explain what happened and how it is that certain policies got enacted or certain situations came to pass that were so, as horrible as they end up manifesting. And that is that it connects to social equality, that is forcing the government official or the powerful person to come and answer and explain, well, how did this happen, is a really important social function that litigation performs. But one of the things that's under assault, and I think the arbitration panel is a great example of that, is that public function of the litigation system. So to the extent that we don't find out when there's wrongdoing, when there are depositions and there are settlements, that they're kept secret, and then the conduct continues because there's no shaming function, there's no accountability in the end of the day because of the secrecy. I think that's a real problem. But we have the potential through this system to reveal really important information. And I've got a million stories that we can talk about as we go on. But much of that information would never come out unless a judge forced a deposition or forced documents to be released. And I'm sure you've all faced that situation where there are documents that would never have come out but for your hard work. And finally, enforcement. I'm not going to say too much about it because it's so obvious how litigation helps us to enforce the law, but it's an important value. And the one thing I would say about that, a lot of my thinking has come from thinking about responding to arguments of opponents to litigation who say that it's wasteful and too costly and limits innovation and just a terrible drag on the economy. Those are the kind of arguments that you hear. But one of the things about being able to bring a lawsuit, which is less relevant to this group, but I think is equally important, is people don't have a basis for knowing that their contracts are going to be enforced, that they can rely on the word of other people, that they can engage in business conduct, unless they know that there's a way to enforce their agreements and to enforce the law. And that's what the job of the court system is. And that's a really important function, not just in a democracy, but in any society where you want people not to be engaging in self-help, by which I mean resorting to violence or other forms of oppression in order to get their way. And the way we do that is by making arguments to a court and having the court decide, who's right, who's wrong, those kind of questions. And so I do think enforcement is really important. It's not just important in civil rights. It's really important in all facets of our society when we have dealings with one another and we need to be able to trust each other. And one of the ways that we create that trust is knowing, hey, if I'm wrong, I have somewhere I can go. I'm not going to just have to lump it every single time. So that's my presentation of the idea of why I think what litigators do is so important for promoting these broader social needs that we have.
You've been involved in a lot of important cases recently. You want to talk to us a little bit about your thoughts about the role of litigation and democracy in the context of the cases that you've been involved in recently?
Sure. Can folks hear me in the back? And first, thank you, Jocelyn, for inviting me. This is my first time at the conference, and I really enjoyed it. It's true, yesterday, I basically attempted to impose the rule of law on my 3-year-old daughter, and basically failed, for the most part. But today I was able to listen to a lot, and I think there's a lot from what happened today in the panels that I was at that resonates with the book. And first I should say, and I'm not saying this to plug it or something, but it's a really good book, and it's a really interesting book. And I'm definitely one of those people who always has thought about my work as promoting my clients' rights and interests, and as promoting the work of people who are not given a fair treatment in the legal system. But I've never thought about what we are doing as somehow kind of contributing in a more general way to the functioning of the society as a whole, as opposed to just functioning as guardians and protectors for the people who are trying to represent whose human rights we're trying to advance. Yeah, and it's a really interesting idea and a different way of thinking about how all of us do our work. When you say like the right to have rights, there's some discussion earlier about just representing undocumented people in all kinds of employment discrimination and other kinds of litigation. And there was this whole wave of cases back in 2000. I think statutes starting in like 2010 in Arizona and Georgia and Alabama, and they were trying to essentially make it impossible for undocumented people to contract and things like it. It feels like very much about that, right? And now, when you think about the Trump administration's attack on transgender people, we were hearing this morning there was a whole panel about protecting various different, categories of LGBT people, but transgender people. The Trump administration is essentially trying to say that they don't exist, right? As a category of people, this is like not a thing, and it really is about erasing the idea of these people as sort of distinct people who would then have rights arising out of their status, as people. Another one that definitely I feel connects to work that I and many others did, so many others did, going back to the start of the Trump administration, is people who are not in the United States but who are seeking to enter. And obviously one of the ultimate messages in the Trump v. Hawaii litigation, which upheld the Trump administration's Muslim ban, is that those people have so few rights, if any, that the standard of review applicable to what appears for any person who just watched the news to be just a blatant, explicit race/religion, discrimination-based policy against them, in fact, was not unconstitutional under a standard of review where basically you just take at face value, literally at face value, the statement of the government in support of the policy. And when you talk about transparency as a goal of, or a value promoted by litigation, I would love to have seen that. There's a 17-page memo apparently that reviews the visa information sharing practices of every country on earth in 17 pages, and concludes that it just so happens that 6 of the countries that have such deficient practices that we should entirely ban most people from coming to those countries happen to be Muslim majority countries that were also countries that the U.S. was admitting a huge number of refugees and other people from. And that's surely preposterous enough that you would at least want to see the document, right? But the holding of the Supreme Court is no, and the government did not dispose that document in the lower court litigation or at any point in time, and no one has seen it. And yet it was, just the kind of representation of what was in it was sufficient to uphold the Muslim ban. I think it's worth thinking a lot about that as a way of thinking about other things that are in your book. I remember the first weekend when it hit, and people all over the country doing litigation, not just the ACLU, but like many other organizations, Muslim advocates. I know Shireen is here. You worked on some of those, I'm going to guess. And so many people went to the airport and just tried to help people over there. I remember that our child was 1 year old at the time, and nobody had planned this. We had no child care, so I went in the morning, went to the airport, and then my wife, who works for Asian Americans Advancing Justice, went in the evening and drove our poor child to the airport, and then we took her out, changed her diaper, and she saw these thousands of people who were protesting in LAX, right? They were just all over the place. And then we put her back in the car seat and drove away, and then Lavani went inside the airport to do the other stuff, And that, in some ways, is an amazing story of the power of litigation, right? Because there were thousands of people there who had gone to the airport. Whoever goes to the airport unless they have to, right? But thousands of people had gone to the airport in order to protest this policy. It was amazing. And we all, multiple lawsuits were filed. It also caused a conversation. I think it did, right? It caused a conversation about the legality of this, even in the press in such a cramped kind of way. It's still a much better conversation than you would have had if there weren't lawsuits, multiple lawsuits that were being filed, and lower courts, not just in the Ninth Circuit, as President Trump said, but also in the Fourth Circuit, and the Second Circuit, and the First Circuit, all over the place, striking down or enjoining the policy. But I also think it's a really good example of the flaws of litigation, not just because of the fact that ultimately the Supreme Court didn't think that these set of people had the right to have rights, or at least most of them. You know, I won't get into all the details because there were certain segments of people who were actually in the original ban who got taken out, all were residents, some of them. But anyway, but I think also because there were really, in some ways, in the long, looking back, counterproductive effects of all the litigation, right? Like the biggest one being that when we got these injunctions, it demobilized all these people who were really upset about what had happened. And so then when it's about, I was just looking this up, it was 11 months later that the Supreme Court, on a stay motion, allowed a bunch of the Muslim ban to go into effect. At that point, there weren't thousands of people in the airport. There weren't thousands of people on the street. The arguments had kind of already been made and this thing had happened. And so you didn't have the same popular uprising that you had had when the thing had gone into effect. And I wonder, looking back, like, what would have happened if the stays had been denied and it had hit the Supreme Court like 6 days later or something, which could have happened, right? That definitely could have happened. And there have been thousands of people, causing chaos all over the airport. I wonder if it would have been different. It's hard. I don't know. It's just a counterfactual. You can't know. But it's definitely true, and we see this in our movement work, that that litigation can have the effect of sapping and demobilizing popular movement, and that popular movement, independent of litigation, also can be a powerful force for social change. And so you have to be, I don't know if there's a solution to that, but that's definitely one kind of dynamic that's at play in this.
Well, I think it's a really important thing to think about, the connection between organizing, lobbying, and litigation. But I also, as you say this, I think there were so many things going on that have needed, mobilization, and I wonder if we really could have kept that level of activism for as long as it would have taken. I mean, it's I think a great question. So what is your thinking about that the role of litigation vis-a-vis the grassroots work and lobbying?
You can hear it. Well, I think you have to have everything, right? You have to move on all fronts. I think one of the things you're sort of alluding to is that it's exhausting. It's exhausting to be moving on all fronts at all times. I mean, I feel like I'm moving on all fronts personally at all times, like never mind the greater political. And it's exhausting. And you as a parent of a young child are aware of that, I'm sure. But I think there is no other, I don't see another way. So if you look at the history of the civil rights movement, the history of LGBT rights, LGBTQ rights, it's all been about multiple fronts. And you really can't give up on any front at any time because, we are up against a pretty significant adversary in those cases, or in all those situations. I do think that, especially with the Supreme Court, and I think judges in general are very sensitive to stories and very sensitive to how it looks what they do. I am fascinated by the outcome in the Hawaii case, and I want to hear more about what you think about how it ended up. But it's a really amazing outcome. Not in a good way. I don't mean amazing in a good way, but a really amazing outcome in light of all the criticism that had come before it. And the dominant literature among professors tends to be that the Supreme Court is very responsive to public opinion. And so there's a sort of a question of what's going on there. Is that something that when we look back on it and we'll say that was the last gasp? Or is it something where it's actually pretending to a future? I can't tell because I don't know what the future holds. But I do think there's a sense in which what was missing at the time it was decided was those stories. It wasn't. I think part of it was the mobilization, but part of it was also the stories of the harm that was being caused. By the time that decision came around 11 months later, they weren't really in the press as much. And I wonder if that's part of it. I mean, people earlier were talking about bring your clients to the legislators so they can see them. It really, I think the human element makes a big difference. And I feel like that sort of got receded into the distance over time in that litigation. I don't know what you think.
Yeah, and I think, going back, I think I agree with what you say about you have to proceed on all fronts. And at least depending on the kind of litigation, I think one thing you can do is try to emphasize in your messaging inside the courtroom and especially outside the courtroom the limited nature of the work you're doing, if in fact it is limited. You know, so like we're doing this litigation on temporary protected status. It's like 400,000 people in the U.S. who the Trump administration took away their immigration status, more or less. The litigation really is trying to reverse the decisions that terminated temporary protected status for these people. But what the people want, and in my view deserve, is lawful permanent residency. There's a lot of people who live here, lawfully residing here since the late 90s and early 2000s. And the litigation can't do that. And so we've tried as hard as we can when we're working with the plaintiffs and with the organizing groups that are doing lobbying and that kind of work as a group to say, the goal here is this, that is lawful permanent residency. What our lawsuit can accomplish is only this, and you can kind of constantly repeat that message in hopes that it doesn't cause demobilization. But it's really hard, as you say, because it's just like, you work on the thing which is urgent right in front of you, and you put it off when you do that. I think that actually case is also will be an interesting litmus test, depending on where it ends up and what the timing is like, for the significance of Trump v. Hawaii, because the government has essentially said, so one of the claims in that case is the Trump administration did this, that has terminated the temporary protected status for all these people out of racially discriminatory motives. And there's a very clear neutral criteria for whether or not to extend TPS or not for a country based on the humanitarian situation in the country, more or less. And unlike with Trump v. Hawaii, we have a lot of evidence that shows that they totally deviated from those criteria. They actually disregarded what all the career people said about how you should extend TPS. And it's a bunch of people from the Trump administration's immigration transition team who went to work for the Department of Homeland Security and essentially hijacked the process and then terminated TPS for all these countries. And so that's sort of like the 17-page memo, like if you actually had it, but I think it's that, right? But the government is saying, oh, the deferential standard in Hawaii v. Trump has to govern this case. It's a case involving foreign policy, it's about immigration and all this stuff. And we'll see. I hope it doesn't get to the Supreme Court at all. But if it does, we'll be in the position, I think, of testing the limits of Trump v. Hawaii.
Alexia, just to circle back on your point about stories, I think we've seen something different, though, in the family separation case. That seems to still have a lot of media appeal, and it seems to have made a difference. And I know, Ahilan, you've been working also on a case involving Counsel for children in deportation proceedings. Thoughts about why? Is it simply it's kids and stories of kids? Kids in cages?
I mean, I wouldn't answer that, but my one brief thing I'd say is just it's because there's no injunction. And then when the injunction came in family separation, it came too late, and there were already all these families that were separated. So, in the Muslim ban case, it's an interesting question. Again, like it had gone into effect. Now we have stories. I have friends who are married. People who work in my office and stuff. They're married to Syrians. They literally can't bring their spouses to the U.S. It's crazy. At the time of the Supreme Court case, those didn't exist because the thing was enjoined, right? So that's it. But I think children's stuff matters a lot too. But I think that's sort of part of it. But I'm curious to know what your.
I think children are innocent, and so there's always and I think the stories of, I think anybody, you don't even have to be a parent, because we're all children at some point, and we know what it means to have a parent. It's so horrifying that I think it's very hard for people to ignore that story in a way that it does appear that some people feel more comfortable ignoring the other. So if somebody's outside of our country or is not a U.S. citizen, there does seem to be among significant segment of the population a greater willingness to ignore their humanity or to say, well, that's somebody else's problem. Whereas when the children, they're here, and the video, there was a lot of videos. I think that makes a big difference. And it came on the heels of some terrible imagery from the refugee crisis in Europe. And I think that the picture of the boy, I don't know if you remember that on the beach in Greece. And it's very, very tragic. I think they did a really good job in litigating that case. So this is a case about the child separation in San Diego. This proceeding in San Diego. The ACLU is doing it.
Yeah, I'm not actually involved in that case. It's called Ms. L.
Yeah, and so I used the materials from that case in my civil procedure class this year. And one of the great things about it is it's incredibly readable. So the complaint is pretty short. The class certification motion is pretty short. It's really clearly written. You really understand the story right away. You could be a 1L 1 month into law school, and you know what this is about. And that it was I think really kudos to them because it was incredibly well done. I've been talking to other lawyers that use different kinds of methods to also tell stories, so photographs and pictures in complaints. Even, I think I heard about videos maybe. I don't know how you would do that, but it sounds cool.
For those of you who were here earlier, Leslie Bruckner's brief has pictures of the kiddie pool.
Yeah, so stuff like that.
It's very
yeah, and there's also a group that has poets and artists on staff to kind of think about communication and ideas. I really think poetry is incredibly powerful, and this is its moment, really. So that's another way that that you can think more creatively about how do we communicate what you guys are seeing when you see your clients. And there was a really deeply depressing story about the winner of the Impact Fund Class Action Plaintiff Award, who was working and they bulldozed his kitchen, and it's but seeing him on the video, being able to connect and see this is a real person who suffered genuine harm, I think it makes such a difference. And a lot of the rhetoric against litigation, against people asserting their rights, one of the things that it does is it kind of tries to erase the people and just talk about frivolous litigation or plaintiffs' lawyers or things like that. But when there's a person attached to it and you see how they've suffered, you come home one day, the kitchen's gone. I think a lot of us can relate to that. Not that we've experienced it, but how horrible that would be. And so I think that's a big part of it. And you can see how powerful storytelling is in some of those arbitration cases. So I don't know how many of you followed the recent trifecta of arbitration cases, and Paul will tell me the names of them, I forget. But the lead case was a case about an accountant who had entered into an arbitration agreement, and the court said it was binding. So in the opinion, the Supreme Court talks about the accountant as agreeing to it. Now the accountant, he's an accountant. He's a white-collar guy, and you would think he might know what this arbitration agreement would mean. But the plaintiffs in the other cases were gas station attendants. And so you have to wonder, well, why does the court tell the story of the accountant when it has a gas station attendant story? And shouldn't the story be justified? If you're going to say there's a rule that everybody has to be bound by these arbitration clauses, shouldn't you have to justify it with respect to the gas station attendant? And it's cheating, I think, not to justify with it. Now, if you have a justification for that, I want to hear it. But it's cheating not to tell that story. And so people make choices, both sides are making choices about the stories they tell, but the people who are really involved in their genuine real-life stories are incredibly important to the whole enterprise.
Any of you who saw the picture of the women police officers yesterday, it was an incredibly powerful picture that told the whole story. So let me move you to a slightly different topic, which is we are seeing a lot of cases now where the new state AGs are coming in on certain kinds of cases. The conservatives are going to the Northern District of Texas or Eastern District of Texas to take a favorite case. Do you think there's a danger that the work that we do will become to be perceived as simply a tool of partisan politics?
I mean, I'm not sure that that it will become more so than at least from the inside. I feel like it already is. I do worry a little bit. I feel like the number of calls from blue state attorney generals asking if we're going to, they want to be anarchists in our cases. I feel like that number has gone up. I'm curious to know if there's data on that, but I feel like it definitely happens more than it used to. But I'm not sure. So it feels like the governments are kind of going to war with each other in a way. I mean, that's interesting. You know, like the state of California arguing amicus brief in our Supreme Court case that there should be limits on how long you detain people. I'm happy about that. Yes, you know, please say that. And they say, okay, we're a state. We detain lots of people. We think there's these reasonable due process limits. There's a part of me which is, wow, the state of California is kind of arguing to place due process limits on detention powers that it uses all the time. That feels like very odd, you know, very interesting. But yeah, I'm not sure that it's more so than it sort of already was. Certainly in my time, I feel like it started, and I'm thinking, of course, in the immigrants' rights area, but it definitely feels like it started in the lawsuit against what they call the DAPA, the broad legalization program, that administrative legalization program that the Obama administration started, and the mechanisms for doing this, and for people picking circuits and all that stuff, they go way back. They go way back. Yeah, they just go like right?
So I would say two things. One, I wanted to say something about the state of California point that you made.
Mm-hmm.
So in Goldberg against Kelly, which I know is like a long time ago. I'm getting nervous. No, I'm not going to call on you. One of the things that the courts does in balancing the interests of the government versus the interest of the welfare recipient in that case, that was a case about how much process should a welfare recipient get before their benefits are taken away. One of the things that Justice Brennan said is that the government has an interest in treating people with dignity. And that is sort of a forgotten aspect. So in a couple of years later in Matthews against Eldridge, which you all will remember, the court erases that from the calculus. The interest of the government is in the fisc, in limiting the amount that it spends on administrative determinations, not in, and you know, there's some interest in accuracy, but not in preserving people's dignity. And I think that's a really interesting omission. And I think it's time for us to think about dignity again. So I would say that I don't have the sense from the prison litigation that the state of California is doing necessarily such a great job in its detention. But I think they have a lot of work to do. But I do think it's great for a state government to say, you know, we care about people's rights. Government can be a force for enforcing rights and protecting people, and it can also, as we've seen, be a force for taking those rights away. And so I think there's something quite interesting about that, and obviously there's ways to use that in other contexts, perhaps, to get some traction. There. So, and with respect to the partisan politics, I have a friend who's a professor at Yale, and he always talks about law's relative autonomy from politics. So law isn't the horse trading of politics that we associate with sort of that workaday kind of partisan politics. It's relatively autonomous, but it's not completely autonomous. And every law that's passed and every decision by a court is going to have deep values implications for the whole society. And that is, in some sense, political, right? It's political both in the broad sense of it constitutes the polity, and also political in the sense of somebody gets something and somebody doesn't, right? But I think it's important. I think one of the things that I'm really struggling with is where do we draw that line, and what is law's relative autonomy from politics? And at what point do we say, this is a nakedly partisan decision, either on the part of an AG or on the part of a judge? And when do we say, okay, there's a legal rationale for this, but I think it's wrong. I think it's morally wrong. I think it's not good crafting of the judicial opinion. I think it's poorly done. Right? There's lots of arguments that we can marshal to critique those decisions.
Well, it's
I think our challenge, part of our challenge, is to appeal to values in a way that makes them resonate as kind of normative commitments that then would transcend politics by virtue of the fact that they are kind of appeals to those values and normative commitments. Occasionally, I can't take any credit for the family separation litigation, but I think that a lot of that was, actually I'm just looking at Bardistan, that's right there, for some family separation litigation in the ACLU San Diego. And I think a lot of what they have done is about appealing to values that are so kind of deeply held that it feels as though it transcends politics, and also in messaging as well. Doing the messaging in a way that you try and appeal to things that are so basic that they're below the kind of political, the kind of first level political reaction. It's hard to get there as we get sort of more and more politicized generally outside of law, just in the society as a whole. I think what's left of that is sort of thinner and thinner. But I think that's the sort of task we're trying to get underneath it.
so some of this obviously is part of Trump's narrative is about, Obama judges and, I'm going to be sued in the Ninth Circuit, I'm going to lose, and then maybe I'll get to my buddies in the Supreme Court and I'll get up their shake. And we got a little pushback at Thanksgiving from Chief Justice Roberts. So I guess my question is, what do you make of that? And then I guess I'm concerned about the census case because, earlier you were mentioning transparency and holding people accountable, and one of the things that the Supreme Court did was prevent Wilbur Ross from being deposed, right? Which is about accountability and telling why he did what he did. So what are your thoughts about that Trump, Chief Justice Roberts' communication about the role of the courts or the whose team are you on?
Well, so I don't have a thought on that communication, but I will say that my observation is that the Supreme Court of the United States will go very far and distort doctrines in order to avoid having high-level government officials be deposed. That's the story of Iqbal, and we have the premier author on that subject actually here today. Iqbal against Ashcroft, which is a pleadings case. I think that case was largely driven by not wanting John Ashcroft, who was by then no longer in government service, by the way, to be deposed. And I think that's part of what's going on in the census case.
In Abbasi, right? The follow-on.
Yeah, in Abbasi, it's the same story.
Same.
And I think that goes to the heart of what I was saying before, that government officials, no matter how high, have to account at the end of the day. And appointed officials are not subject to the electoral politics. And so it's very disturbing when the court is willing to go so far. And if I don't know how many of you followed the Iqbal case, but there was a motion to dismiss for failure to state a claim. And it went up to the Second Circuit. And Judge Newman on the Second Circuit, who's a very excellent, moderate judge, said, lower courts can manage discovery. Nobody is saying that John Ashcroft is going to be deposed tomorrow. First, we'll do some document discovery. We'll see what there is. And then we'll decide whether there's cause to bring in these high-level officials for depositions. We recognize that's a really big deal. And the same is true in the arguments over the census case. You see a lot of respect at the lower court level for saying, we're not going to willy-nilly drag in every high-level official on plaintiff's say-so. And yet the court doesn't trust district court judges. And that's why you see outcomes like Iqbal, like Abbasi. And so that is a worry in that case. And I just want to say, though, that those depositions are incredibly powerful. So it's not a deposition, but I was following the litigation in Kansas, which is also, I think it was in Kansas, the ACLU litigation, where Chris Kobach was on the stand. That's incredibly powerful stuff. And that's the only place where that person was held to account. Was in a court of law, sitting on the stand, being questioned and cross-examined fairly, right, under all of our rules. That's what the rule of law is. It was, you know, it was obviously excellent lawyering. But it's important to remember that it's possible to do that. Nobody died. It was, you know, there was a, and if you follow the census litigation, you know, one of the administrative, one of the people who runs the census, who's an administrator and a statistician, I think he broke into tears on the stand because all his hard work was ignored by the authorities. Those kind of moments are incredibly powerful moments. And we don't get those moments in everyday political discourse. That time when somebody's really pushed to explain, why is it that you did this thing? You know, we see it also in the Prop 9 litigation here in San Francisco, where people had to say, well, what is it exactly about marriage equality that you're opposing? What is the injury here that's going to be caused by this change in the law? And they weren't able to articulate a reason other than animus. They just weren't able to do it. But that's the moment where where push comes to shove, you know, and you don't get that in ordinary, in the kind of political discourse that we happen to have in this country at the moment. We're not getting those kind of conversations.
Well, so for any of you who were here last year, I think Cheryl and Eichel did an incredible job explaining the importance of making a historical record and having a set of rules whereby witnesses talk and we come to some sense of truth. I think it was really powerful, and I hear the same themes here. Lexi, you also talk about the role of juries, and particularly in the concept of participation. So can you talk a little bit about what it means for people to be jurors and establish some values for us? So
my knowledge of the jury right is from very short stint as a litigator and then a lot of social science data on the jury. And most of the data show, as you all may know, that jurors take their job really seriously. We do have a history in the United States of a lot of prejudice surrounding juries, a history that we should be careful of people being excluded from jury service, of all white juries convicting black defendants on basically no evidence. So it's not that our history is not replete with problems. But one of the great benefits of the jury is that it allows ordinary people to participate in the justice system and also to make judgments about what's right and what's wrong. So one of the things that, you know, just to take an example, I don't know if you guys are familiar with the Lyons case. So that was a case in which the Supreme Court held that a person who had been illegally stopped by the LAPD and held in a chokehold could not bring a class action, did not have standing to bring a class action because he couldn't show that he would be in a chokehold again. And it's only the threat of actually being injured again that will allow you to bring a case, right? So, you know, that's, I think, incorrect. I would disagree with that ruling. But in addition, one of the things that it takes away when we don't get juries to hear that question is the community doesn't get to decide where do we draw the line in terms of law enforcement behavior. And that's one of the ways in which qualified immunity and other doctrines that prevent juries from hearing these cases, we don't get to hear from the community what they think about law enforcement behavior. So if you guys followed, I don't know if you did the strip search litigation in New York, one of the things that the judge in that case, that was an injunctive case, there was no jury, but the judge toyed with the idea of impaneling an advisory jury, which the federal rules do allow. And she thought, well, it might be helpful, rather than having a single federal judge decide this, to have input from the community. Now, it's only 12, but input from the community about this policy. There was a lot of dispute in the community about the policy. But I think the jury serves that important function. And really, all the studies show that juries and judges agree on liability most of the time, like 80% of the time. And the juries take their job really seriously. And there's a really interesting study that actually shows that variance in verdicts among jurors is lower than variance in pricing injuries among judges. Right. So just think about, so just think about that. I mean, that's really interesting. That's one study, you know, I'm not saying it's definitive, but I think that's something that we're thinking about. The other thing we were discussing earlier is, you know, when I teach about the jury right, my students' standard argument, which I think is a good argument and a traditional argument, is, well, judges are going to be less emotional, less prone to passion than the jurors would be. And I ask you to think about that in light of recent events, whether in fact we believe that about judges. Now, I don't want to impugn judges, but I think we do, all of us are human beings with emotions. And it's very, very important to remember that when you take on the mantle of a judge or a juror, you're taking on an adjudicatory function. It's incredibly important and incredibly powerful. And I think jurors really understand that and take it incredibly seriously. And there was a recent case, I think it was here in California, a trial against Monsanto arising out of an allegation that product Roundup causes non-Hodgkin's lymphoma. And the judge was deciding whether to remit the verdict. And the jurors wrote letters to the judge explaining their decision to try to convince her that they took this very seriously and they had reached a decision. And I think the extent to which judges undermine juries is problematic, because the jurors really are spending a lot of time and they're taking it really seriously, and I think we should respect that, with the caveat that it's not a rose garden, and there's plenty of concerns that we might have about jury behavior, especially in the criminal context.
One of the things I found, that's one of the parts of the book that I found really interesting and totally, like, I did not know any of that. The stuff about, because I think also you imbibe it in law school and all over the place, this suspicion of jury. I did jury trials when I was a public defender in El Paso, and we definitely, I think, had faith sometimes in the juries in those situations, but somehow it like washed out. And now I do injunction cases for the most part, and kind of are scared of them. One of the things that the book talks about is, one of the things the book talks about is also modifying instruction practices, right? So, I think if you tie their hand completely, if I couldn't take notes, I'm like taking notes here while we're chatting, like I can't, kind of keep up with all the things that are going on in a presentation without being able to take notes, and obviously the way the instructions are read. And I remember being, even in my criminal trials, which are obviously often much simpler instructions than what you would get in civil trials, there's just no conceivable way that anybody could listen to that. This was like even before cell phones became the dominant, after 7 seconds you pick up your phone. There's no way anybody could listen to this stuff and not just zone out and completely lose it. And so I think you have different ideas in there about how we might give juries a fair chance to actually understand what their job is, the way that you would in normal circumstances, like being able to take notes and changing the way the instructions are received and stuff.
So, thinking about this narrative that we often face, which is that litigation is frivolous and it's all about the lawyers. Obviously, the Impact Fund's been trying to do a lot of work in terms of figuring out how to communicate about what class actions are and what the benefits are, and making our class notices better. What are your thoughts about how we best talk about litigation in a way that reaffirms the values that you've talked about, as opposed to this other Chamber of Commerce narrative?
Well, that's actually why, the reason I wrote the book is I felt that there wasn't a counter narrative out there. But the narrative of frivolous litigation and sort of overtaking everything and become incredibly powerful. In general, right now, I think a sort of simplistic economic model seems to be the dominant kind of ideological construct under which we're all laboring. And so there's lots of ways in which it's flawed that I think are now being pointed out more than in the past, but have really kind of have not been as successful as we think they would be given lived experience. So the sort of rational man model of economics seems to be so dominant that it's hard to access arguments against it. But I think that empirical studies that show, look, even under the 1980s rules that were so much more generous than today, medical malpractice, injured people, fewer than 5% of people who were injured by medical procedures brought out lawsuits. People just don't bring lawsuits. It's not an enjoyable experience to bring a lawsuit. It is something that people do when they're really hurt. That does not mean that they always win, but it's something that people do when there's a tear in the fabric of society, when something really bad happens to them. And the irony is, everybody's against litigation until something bad happens to them, and then they're really in favor of it. For them, and not anybody else, right? So there's a little bit of a like closing the door behind the thing that goes on. But I think you have to combine, all the rigorous empirical studies show that there's very little civil discovery, almost none in most cases, which is a worry because that means information is not being exchanged or getting out. That there aren't runaway verdicts most of the time. Verdicts are pretty low. That, and that people actually lack access to justice rather than having too much access to justice. That's what the empirics show. But I think those are helped along by stories that really speak to people, where they can see and relate to the kind of injury. So the panel right before us was talking about the nursing home cases in arbitration, for example. There was a New York Times series of articles about people who were shut out and unable to access their rights because of arbitration. Those are very powerful stories, and I think they speak to a lot of people. And I think most people don't have a need, thankfully, to access the civil justice system. Their lives go pretty well, and that's great. But that means they haven't really reflected on it very much. And so there needs to be, I think, more education about what the system does and why it's valuable and why people are doing good work to vindicate rights in it.
I also think that there's a story to be told about the civil rights benefits of litigation and the need to keep courthouse doors open. That obviously will only appeal to a certain constituency, but I think there's probably a lot of overlap in the constituency of people who feel skepticism toward the legal system in the ways that we sort of all know about, and about there being too much discovery and frivolous lawsuits and all that, and people who would really be concerned about the idea that you have closed the courthouse door on the most extreme, say, prisoner brutality, like through the PLRA, or the death penalty, right? I think you can draw a line. It's not as it's perfectly straightforward, but you can certainly draw a line from like EDPA, which is the statute in 1996 that massively limited post-conviction appeals, and the sort of horror show that like the Innocence Project and all these other groups have kind of been able to show, as you've completely restricted court access in that context. And in the immigration context, it's a huge thing. So many of the worst abuses of the immigration court system cannot be remedied because laws passed in the mid-90s make it impossible to bring class actions in the district court where you can actually do discovery, like you mentioned it earlier, this work on trying to establish that children facing deportation have a right to appointed counsel. And there's something like 30,000 children since 2014. Now it's more than that. Almost all of them from Guatemala, Honduras, and El Salvador, which are like 3 of the 5 most violent countries on earth. About 30,000 children were unrepresented and were ordered removed. That is, they have deportation orders, and they never had a lawyer. And they got ordered deported because they failed to appear in court. And they're children, right? I mean, many of these children are under 14, like I think something like 40% or something like that. But there's like tons of, they didn't have the power to choose whether or not they would come to court on their own, right? It's so crazy. But the courts have ruled thus far anyway, these are like my cases that I've lost for the most part thus far, that you can't bring a class action to challenge this, to challenge the lack of a right to appoint, the lack of lawyer, or the challenge to the sort of resulting deportation orders, because you have to bring those in individual challenges in your individual deportation case. And it's actually quite analogous to arbitration. A lot of it was talked about. It's like you have to go through the administrative system one by one rather than doing class litigation. But this is not. This is something which is, and that's one example affecting 30,000 children and their families. There's lots of other kinds of systemic problems in that system also that affect many more people. But it's not something that's been high on sort of the immigrant rights movement's agenda, because it feels like very kind of, this is just like about law and courts and stuff. It doesn't feel like it's about much in the same way. I think you could say something, I don't know, where EDPA would fit in the criminal justice. Like you don't hear about that, right? Like EDPA reform is not like the top of the agenda on criminal justice reform stuff that you hear about. And I think there's a story to be told about how access to the court, because it's so important to create the kind of protections that you're talking about,
it's also central to kind of civil rights agenda more generally.
Let me throw it open to questions if people would like to ask. Yes.
I'm fascinated by the concept of private attorney generals and fee-shifting statutes. I wondered maybe if you could comment or address the aspect of rights protection and rights enforcement within the context of litigation and democracy.
So the question was about the private attorney general concept and fee-shifting statutes as a way of enforcing civil rights. In the United States, in the 60s, there was a question of whether to enforce civil rights more through an administrative state. The example would be the EOC, which is a pretty weak administrative agency, or to do most of our enforcement through more individual or class actions that are brought by private citizens. And I think consistent with sort of the liberal American individualistic approach to most things, the decision was made to really focus on enabling private parties to bring litigation enforcing civil rights. And one of the ways that that was enabled was through fee shifting. So if you prevailed, you can get some portion of your fees. And it's a one-way fee shift. And so there's a really interesting book by Sean Farhang, who's at Berkeley, about why it is that the Republicans, during that period of American history, signed on to this private attorney general model. And what does it mean about the separation of powers? So why would we farm out civil rights litigation to individuals rather than having it be centered on the administrative state? And in part, one of the concerns was that the president has a lot of power over administrative agencies, whereas if we distribute power in this private attorney general model, in fact, you're going to get a better kind of enforcement. I also think it has this market kind of quality to it that's very attractive. But it is, our primary way of enforcing rights is by having private actors see a wrong and try to fix it. Does it have to be that way? No, there are plenty of other models where it's not that way, but it has been the choice that we've made for the last, 50 years. And so that's where we are.
Your question, I don't know if you were asking about key tam suits.
Oh, that's another.
That's another aspect. Yes.
Yeah, I mean, I think they're not available for injunctions, in the kind of cases, civil rights cases. It's a fascinating idea. I think the problems of like lions. You've got that on one end. You could imagine a very relaxed standing regime. And it could be just you could relax it by not requiring you to, face death at the hands of the LAPD a second time. To like a much more revolutionary idea, which would be, I'm not the child who's facing deportation, but I, have met lots and lots and lots of them in immigration court and sometimes in detention centers, and so maybe, I should be able to bring a lawsuit on their behalf rather than having the extremely narrow kind of next rent rules. Essentially, I can only do that now if they can't get to the court at all, and even then, I couldn't do it. Their family member could do it or something like that. And those are all kind of interesting ideas that you could use to as sort of another way of opening up, better access to the court system. I think our standing rules. I'm not a comparativist at all, but just from what little I know about like Sri Lanka, India, France, I think our standing rules are amongst the most narrow and restrictive of sort of anywhere where you have kind of common law systems operating. So
Yeah, getting worse.
yeah.
It comes narrow over time.
Yep. Other questions? Yeah.
So the left has largely been in favor of litigation and in favor of courts as an avenue for social change relative to the right over many decades. As we look at the prospect of an increasingly conservative Supreme Court, perhaps one that will be like that for the next generation, do you think that we'll see kind of a dialing back of rhetoric, or should we see kind of a dialing back of rhetoric in favor of the courts, at least as a vehicle for social change, political change, And in a sense, do we need to be prepared for a time in which maybe our arguments will be more about delegitimizing at least the role of the Supreme Court in the political sphere? And I think it just puts us in a very odd position to think about that, but it's not unrealistic to think that over many years potentially we're going to have to talk about why the Supreme Court is getting it wrong. I mean, it's not that we've not been doing that, but to an even greater extent. And so how should we be thinking and talking about the role of courts versus political institutions given that context?
I mean, for me, I don't see this as new. We have been trying, I don't mind saying this on a recording, I feel like everyone knows it already, meaning the ACLU, since I've been there, I was there in 2000, and we've been trying to keep cases out of the Supreme Court for the most part, most of the areas that we work on from then. And I would have loved to have been alive during the Warren Court. I feel like that would have been so cool. But I guess when I see the big, it remains to be seen the relationship between sort of Kavanaugh and Kennedy, and Roberts versus Rehnquist, and these other kinds of things are it's sort of hard to Gorsuch and Scalia. But it doesn't feel that the difference is that this appears to be the way it's going to be now for decades more, unless some of these ideas about court packing and things, take hold. And actually, I think there's a very good argument for having an even number of people on the Supreme Court. Actually, and I said that when I was in law school. It just seemed very odd to me. So it's not like I don't say that because it's very, very odd to me that we have an odd number of people on the Supreme Court. But that aside, I think that it doesn't really change the way we have approached a lot of our work. And then the other thing I would say is, the Supreme Court historically, other than those years of the Warren Court, it's been a pretty regressive force, kind of when it comes to social change, going back all the way to the start, right? Since it sort of gained the power of judicial review and stuff like that. When changes have come, often they have come because of massive shifts in popular belief, and then state and local change that eventually bubbles up. And I think a great example of that is the marriage equality, issue itself. I mean, the Supreme Court, I think in 1972, is Baker v. Carr. It's a case they dismissed for want of a substantial federal question, a case presenting an equal protection challenge to a constitutional challenge to a law that prohibited marriage between two men. I think it was same-sex marriage. And that Supreme Court, by every measure, when you see these measures of left and right in the Supreme Court, that Supreme Court was much, much, much more progressive than the Supreme Court that struck down both the one that struck down the DOMA and then the one the over-decal Supreme Court. And what changed is obviously nothing about the court. It's popular conception and the society changed. So I feel like that strategy for success, which is so hard, it's so hard, but I feel like that strategy is not fundamentally different to me than the strategy for what we've tried to pursue, at least the last several decades.
I guess I would also say, yesterday I was talking about lots and lots and lots of cases, and the Supreme Court can only take 60-something cases a year.
Well, it can take more.
Yeah.
And it shouldn't
Right,
be not
exactly.
good.
What, like 100 and something?
We used to take 120, now we take like 70.
Yeah.
All good, all good. So there's lots of work that the worry really is who the district court is in my mind. But
Yeah.
So we've come to the end of our time. Please thank our panelists. We have also come to the end of our conference. Thank you all for coming. Again, I want everyone to thank Lindsay, who made this the very last time we were told to please fill out your evaluations. I want to also thank all of our sponsors and nonprofit partners. I want to let you know our annual event is going to be May 7th this year, and we are honoring Joyce Vance, who will be there to speak. And this conference next year, if you want to put it on your calendar, it will be February 20th and 21st. So safe travels to everyone, and thank you so much for coming.